Hi, everybody. This is John Root again from Proceptual, and I am so pleased to be joined today by Rob Szyba from Seyfarth Shaw. Rob is an attorney who's focused a lot of his work recently in exactly the area that we're all here to talk about, which is AI compliance in human resources and hiring. Hi, Rob.
Hey, John, how are you? How's everything?
It is amazing. I am happy to be here. I am happy to be 3 weeks out from New York City Local Law 144. It's a big moment, I think, for all of us in our little community here. I'd love, Rob, for our audience, if you could just give some background as to what kind of work that you do as an attorney, how your career up to this point has kind of led you to your interest in AI and the regulations that we're going to be talking about.
Absolutely. So first of all, thank you, John, for having me. This is absolutely a privilege to be chatting with you, and thanks so much for the invitation. So the evolution of Local Law 144 really started probably about I'd say 2, 3, maybe even longer years ago. Over the years, there's been a lot of interest in developing more efficient technologies, better technologies that are both geared for the HR functions of recruiting, employees or recruiting talent, getting better at identifying people who are better suited to a role, as well as eliminating any type of the human biases that people have in making employment decisions, whether it's in recruitment or within hiring or promotion decisions. So as those challenges sort of existed, I think couple of years ago, people looked at technology as a potential solution to eliminating human biases out of these decisions. And, folks got creative and developers got creative and figured out ways of creating algorithms that assisted with that process. And what the intention generally seemed to be was to do two things. Number one, be able to make more streamlined employment decisions. In other words, a recruiter doesn't have to sit for hours and hours looking through resumes. A recruiter doesn't have to sit through hours and hours of interviews. Let's see how we can streamline and make those processes more efficient. And the other goal was to create a situation where that recruiter that's sitting there, the process is not infused with whoever that recruiter is and their own personal proclivities or biases or tendencies to lead in a certain direction or not. Or, what we hear about sometimes, you gravitate towards the people that remind you of yourself. So the technology was sort of seen as a very, very great opportunity to eliminate those sort of, human tendencies. And over time, we've seen the evolution of a tremendous amount of employment tools that do a variety of different things, whether it's processing high volumes of applicants and resumes, whether it's searching out certain, talent with certain qualities, whether it's making decisions, whether it's predicting who might be better at what type of tasks or what kind of jobs. And, the imagination is our limit. I mean, it really, any aspect of the recruitment or hiring or HR function has really benefited from these types of tools, and developers have looked at all kinds of variety of different ways of improving that process. So that's the backdrop. And as we sit here today, as relevant to this law, a couple of years ago, the New York City Council decided that this was an area that was potentially going to create risk for New York City's residents and workforce. And the New York City Council determined that there was the potential for having, for these types of tools having a disparate impact on certain groups. And in order to eliminate that possibility or mitigate that possibility, the New York City Council passed Local Law 144 in 2021. So this law is now a year and a half old, technically, from the date it was passed. The intention of the law was effectively to require an audit, a bias audit, as it's called under the law, so that companies that are using these types of technologies, which the law refers to as automated employment decision tools, to do an audit to make sure that tool doesn't function in a way that creates a disparate impact. And number two, to provide notice to applicants and talent and, folks that are up for promotion when these types of technologies are being used. And I think the thought process there was to say, what we don't want is secret stuff happening that nobody knows about. And the two ways of doing that are going to be tell everybody you're using that tool, and then do an audit to make sure that tool is functioning in a way that's not negatively impacting one particular group versus another. And then ever since that law got passed a year and a half ago, the Department of Consumer and Worker Protection has been working on regulations and figuring out how to better regulate under that framework of, what bias audits require, how to do them, who does them, what kind of notice is given, what that notice has to include, how is it given, to whom, and so on. So that's kind of the evolution. And to answer your second question, a tiny bit, because I know I've been chattering over here for quite some time. I am a career employment lawyer. I started in, law school with an interest in employment law and the different impacts that employees and employers experience under the law. And that's sort of how I found my way to this law. It's another regulatory scheme that regulates what employers, have to or can't do, and how that impacts and, protects employees in the different contexts that come up with automated employment decision tools or the hiring process or promotion process.
That makes sense. That's a great background, and it's a good segue to my first question for you. So you had talked about, this law is a year and a half old and passed by the city council, and then it goes to the relevant regulatory body to do rulemaking. And we have been through, I believe, 3 extensive written sets of rules. And then we also, I know you and I, and probably several folks in the audience attended, I guess it was 3 weeks ago now, that employer roundtable with the city. And I left that experience personally, learning a couple things about the law, but also seeing some more ambiguities that I may not have seen before. So could you talk, if you would, a little bit about, for the work that you're doing with your clients now, where are you seeing uncertainty or ambiguity in the law that you and your clients and the employers listening should think about having to navigate around?
That's a great question. And funny that this is your first question, considering that I've been going on and on and on about the preliminary things that we were discussing. No, I think that's a really great point. I think the challenge to keep in mind overall is that this is the first law of its kind. This is the first time that any type of actual law has been passed that regulates at this level with this type of requirement the types of technologies that are emerging. So we have multiple problems that are competing at the same time. Number one, we have things that are happening in the world that really, like I said before, are limited by creativity. So we have a lot of different tools that function in a lot of different ways, that utilize a lot of different technologies or technological systems. There's not one thing, there's not one tool, there's not one type of mechanism or algorithm or artificial intelligence that is trying to be regulated. It's really all of them. And as the creative types come up with different tools and technologies, that really pushes at whatever definition a regulator might be trying to create, because there might be some aspect of the tool that exceeds that definition or falls inside or outside. So that's the first challenge, is that what we're trying to regulate is still moving around. It's hard to swat at something that's still very live and moving around and trying to find new ways of operating. So that's number one. Number two, the things that employers do in the world, a variety of different things. We see employers that are using a variety of tools for sourcing talent. So, for example, an employer might be going out and trying to find new people that it hasn't seen before. They might be using the tool to analyze an applicant that has applied, or somebody that has interviewed, or somebody that is already an employee and trying to optimize that employee's tasks day to day. They might be using that tool to do a personality assessment of an employee. There's so many different uses to these technologies that it's also hard to pinpoint which functionalities are at issue. Are we talking about sourcing candidates? Are we talking about assessing candidates, ranking candidates? And we have a little bit of clarity now from the Department of Consumer and Worker Protection, but that's one of the challenges, is which function do we want to regulate? And the last challenge is, to be perfectly candid, the problem is that we have developers who are developing technologies who are very sophisticated and advanced in their understandings of these technologies. We have HR personnel and managers at companies that are using these sophisticated tools in a sophisticated process. And then the challenge is that we have the New York City Council and the New York City Department of Work and Consumer Protection who don't have that personal connection to those things that happen. So they sometimes might not have as great of an insight into the depth of the technology and the sophistication of the technology. They might not have the personal connection to know exactly how these nuanced systems or procedures or uses are being implemented. So what we're kind of experiencing is a broad net of regulation. The challenge of defining what is to be regulated, the automated employment decision tool. And I mean, if you think about it, that definition alone is a wide net, because it's not just artificial intelligence, it's not just machine learning, it's not just a particular type of tool. It's an automated employment decision tool, which is effectively, until this law really came out, a term that nobody was really using. So the challenge and the ambiguity is figuring out what these things, what are we trying to regulate, and how are we trying to regulate it? And there's other aspects of ambiguities in the law as well, with regard to the bias audit and how that's supposed to work, with regard to notice provisions. One of the challenges that I've been working with a lot of clients on, first of all, figuring out which tools need to be audited pursuant to this law, how we're supposed to give notice under this law, as well as something as seemingly simple as, where does this law apply? If you have a job that's sitting in Midtown Manhattan, okay, maybe that's a relatively easy analysis. But what if you have a remote posting by a company who has offices all over the world, and the position might pop up all over the world for, wherever you hire someone? It becomes a very challenging analysis to determine, is that use, is that tool, is that situation covered by this law or not, from a jurisdictional perspective. So lots of fun things for us to talk about when we talk about ambiguities, because all very specific and all very very intensive analyses that we have to perform to really figure out how to navigate through these requirements.
Yeah, that's a great answer. And I want to pull the thread a little bit on the last one that you talked about, because it's having to do with geographically what employers and what employees will the law apply to. Because I think when I had read the first version of the law, this was back last year, it seemed to be saying that anyone who was physically in New York, regardless of where the employer was probably under the law. So, but now we have, from this live meeting just a couple of weeks ago, we got more analysis on that. So, as you said, it's clear that if the employee and the officer in New York, the law applies. If there's no office in New York and the employer lives somewhere else, it doesn't apply. But then there was this whole middle ground where, exactly as you said, if there's a remote employee working somewhere outside of New York for a company that may have offices in New York, but may not be based in New York, they called it fact specific. And,
Right.
That makes sense. And I understand that, it was nice of them to schedule a 60-minute webinar for us, and they can't answer every single question. But what's the employer supposed to do with that? If you're in that gray area, how should you start to think about the question?
Ultimately, if an employer has a physical location in New York City, on some level, you have to start thinking about New York City laws, even if it's for remote positions. And it might be a very quick thought. It might be, a pretty easy answer that, yes, we have an office in New York City, but this has nothing to do with New York City at all. This has no connection, no tie-in. It might be a very easy answer, but it behooves, everybody to start thinking along those lines. If we have a touch point in New York City, how is that bleeding over? How is that impacting some of the things that we might be doing globally? And it really relates to remote positions. When you have a position that's hybrid, for example, in Arizona, it might not be that big of an issue, because somebody's showing up to work in Arizona, presumably they're going to be in that geography. So that might be an easier answer on its own. But ultimately any entity that is either doing business in New York City by way of having a physical location there, or potentially, I would say, doing business in New York City by way of hiring people that are in New York City to function in New York City. If the intention is to have someone in Manhattan or in Brooklyn or in the Bronx because of, let's say sales positions are an easy example. If you need a sales rep who's operating in the Bronx to, service your account, service your customers, you might not have a physical office, but you have an intention to operate and do business on the ground in the Bronx. And I think ultimately, as employers are thinking about these things, on the one side, there's ambiguity because, on the one hand, it's uncertain as to whether the law applies and what are the criteria. On the other hand, the good thing about it is that an employer who is in that position can also think through, how is this position structured? How is this employment relationship structured? Is there a way that we can structure this that makes more facts on our side to suggest that this position will be outside of New York City? So, for example, that sales rep that's operating in the Bronx, maybe instead of having that sales rep be in the Bronx, maybe we have an office that's in Westchester, and that sales rep could work out of there. Maybe that's a solution. So there's also an opportunity to figure out what's the best way of doing this so that we can navigate the legal landscape. Because frankly, New York City is not the only jurisdiction that regulates things. Surprise. A lot of other cities, a lot of other counties, a lot of other states have a variety of different legal obligations to navigate as well. It would be impossible for any employer to sit down and say, I need to know the law of every jurisdiction in the entire country and then try to figure out what's the quote unquote best one. An impossible task. I mean, we'd spend a lifetime trying to figure all that out. And by the time we, got halfway through, all the laws would have changed. So at the end of the day, these types of analyses, this types of thought processes really have to happen. And this is a good, a good catalyst for that. We have this law. If we have a remote position, now's a good time to think about how that impacts our workforce.
Let's pull that thread a little bit more, and let's get the big dog involved, which is EEOC. And so EEOC just a couple of weeks ago now put out this quite lengthy discussion about how they're planning on thinking about and how they're planning on using their regulatory authority on automated employment tools. I guess I'd love to start relatively broad, and then the answer I'm ultimately trying to get to, and we can go around a little bit to try to get there, because the big question is trying to figure out what should employers do about that. So an employer that's trying to think about what should we do for New York, maybe, but also sees, okay, EEOC has been clear that Title VII and ADA and these other federal regulations still apply. How should the employer start to think through their strategy for compliance?
Well, let me ask you, John, for a second. The EEOC, what's to say that they're not already regulating artificial intelligence?
Well, I think that they would say that they are. I think that their answer, which is smart, would be to say that they have had regulations in place for decades, and that the decades explicitly now apply to those tools. And so there's I guess the question you asked me back is a smart one. And then so my question back to you will be, how should a company that uses these tools is now certainly informed that EEOC is going to be looking into those tools for the same sort of discriminatory impact that they would have a paper and pencil pre-hire assessment 20 years ago.
That's exactly right. That's exactly right. And I think it's a mistake to think that the EEOC is not already very deep into the artificial intelligence space, because they really are. I mean, they have been recently very explicit, but it didn't really take recently, the recent comments to figure that out. As you correctly point out, Title VII, the Americans with Disabilities Act, the Age Discrimination Employment Act, all these laws have already been on the books for decades, and they regulate the various things that happen in the employment relationship already. They're not specific to any particular tool or any process or anything like that. Title VII prohibits discrimination and disparate impact on particular groups based on race, gender, and a variety of other protected categories. It doesn't really matter if an artificial intelligence tool is being utilized or not. So the thing to really think about is at the federal level, the EEOC already has these laws in place. And you could argue the same at the state and city level in New York. The state has its human rights law, the city has its human rights law. These laws already prohibit the types of discrimination that Local Law 144 was a little bit more specific in its requirements, but the same type of discrimination that law is trying to prevent. So along those lines, for the EEOC's purposes, the EEOC is not necessarily requiring a bias audit per se, as New York City is, but the EEOC has, for now decades, had the uniform guidelines in place, I think since the 70s, that give a framework for employers to utilize when assessing how their processes or how their procedures or how their selection criteria are utilized in making employment decisions. That's not really new. There's new attention being put on it because of what New York City is doing, but that's something that's already in place. And I think if you were to ask the EEOC, you would probably hear something along the lines of, this bias audit is a great idea. Or they might, be a little bit more reserved. They might say, yes, it's a nice idea. But if this bias audit is something that an employer can do to figure out discrimination based on race, well, then the employer should probably be doing something similar to determine if there's any discriminatory impact based on national origin or ethnicity or race or gender or age or disability or any other protected process, but protected category. So I think the system already, at the federal level, the system already exists. It's not specific to AI or artificial intelligence or automated employment decision tools, but that system, those criteria, those guidelines for, at the federal level, it's not called a bias audit necessarily, but there's already criteria that exist for that. So as an employer is thinking about a New York City bias audit and conducting that, I'd say a little bit of the tip of the iceberg, because that's a need to have for New York City purposes. But at the federal level and on a much global level, the same type of thought process of, let's assess our device or tool or system or process to make sure that it doesn't have a discriminatory impact is probably something that should be happening on a global level under the federal law. And it would not be limited to New York City or the specific protected categories in New York City. On the flip side, the same type of bias audit that needs to happen in New York City is not necessarily required at the federal level. So there's a framework, but the specific requirements and nuances are a little bit more generous under federal law.
Gotcha. Yeah, that makes sense. And then I think that my final question kind of ties some of this together. So one of the situations that we as the independent auditors have found is, if we do one of these audits, we're auditing over race, and there's obviously many categories of race. We're auditing across gender, and then we're auditing across the intersectionality of both of those groups. And if you take a data set and cut it up into infinity number of pieces, eventually you will start to find some evidence of disparate impact, because if you run the same tests, the law of large numbers says one of these tests is going to be in on the wrong side of the 80% rule. So let's say that happens, and this is a situation that we deal with every day. So we do the New York City audit. The company is ready to post it, but then comes back to us and says, hey, wait a second, one or multiple of these groups shows disparate impact. How should, in your view, the employers start to think about what to do in that situation?
Well, in that situation, and I don't disagree with you that depending on the data, and I'm not a statistician. I'm not doing these bias audits personally, but I am working with clients that are going through the process and walking with them while they work with independent auditors, just to make sure that the audit is being done, not just in compliance with the law, but in an optimized sort of setting. that that's a great point that you make, that, depending on how, the types of data that you put in might impact the types of data that come out. But to your specific question as to what do you do if you have a bias audit that reveals that there's some sort of discriminatory impact? Well, I would say we really can't be using that tool. Because if you think about it, I mean, simplistically, if you're doing something that's causing discrimination, you wouldn't continue doing that if you did it, if you knew about it. So I kind of look at it as, back in the old days when you would get your car inspected and you get the inspection sticker. At the end of the day, it kind of, in my mind, works a little bit like this. You take your tool, like you would take your car to get inspected. If you don't pass inspection, you have to go back and get it re-inspected until you pass, until the car is fixed and you pass, and then you can drive around to your heart's content. And it doesn't work that much dissimilarly in this context. If you have an automated employment decision tool that winds up having a result that doesn't meet the criteria of New York City, you would have to go back and work on that tool and quote unquote fix that tool until it did, and then rerun a bias audit, make sure that it passed. Once it passed the bias audit, in my example, passed the car inspection, then you can use that tool for that, for the following year, because the bias audit is only good for about a year. And that's effectively what's going to need to happen. An employer that, I can imagine a situation where an employer has a bias audit that reveals some sort of discriminatory impact. It wouldn't make any sense for you to post the audit results on your website, say, hey, we're discriminating and we're continuing to do it. You wouldn't do that. So ultimately, that's, that it kind of works in that way. You do the bias audit. If you find there's a problem, you address the problem, do a bias audit again, make sure it's fixed, and then you're good to go for a year until you get to do your next bias audit.
That's a great answer. Well, Rob, this has been an amazing discussion. I know we've reached the end of our time, so I want to thank you again for coming on. I think this will be enormously valuable for our employer audiences, and thank you so much for your time today.
John, thank you very much for having me. It's been a pleasure chatting with you, and hope to work with you again. Thanks very much.